Dear colleagues and dear friends, with your permission, we are starting our plenary session. As a moderator on the Russian side, I'm going to open the session, and I will say several words by way of introduction on the topic itself in this plenary session. We will be introducing the speakers one by one with my colleague from India, whom you have already heard today. We have divided our responsibilities in the following manner. I will be introducing our Russian speakers, and he will be introducing foreign speakers. The topic of our plenary session is international crime levels and all the problems it entails, the conflicts connected with them, and ways of resolving them. The most obvious example in the highest level of conflict in the theory of conflictology apart from world, local wars and local wars, is criminology. Tapes of conflicts, as well as possible ways of resolving them, through compromise in particular, were very clearly presented by Professor Ivan Kozachenko, who I would say is an adept and an apostle of Danila Sergeyev. They spoke extensively on ritualization and theatricality of the procedures aimed at mixing these conflicts and on searching for a compromise in fighting crime. To these two rather new terms, I would add another one. It is not even theatricality. It is the so-called legislative farce, which is closely connected with our legislators, introducing and including into the Criminal Code of Russia multiple new rules in the course of 22 years, which have intensified criminal repression beyond all capacity. These new laws, mostly superfluous, sometimes senseless, at times harmful, have broadened the limits of conflict so much that law enforcement is now faced with the problem of solving the problem of laws themselves, and they do not always succeed in doing so. The disturbing role of the legislator leads to conflicts artificially appearing in fighting crime. Present here today is Professor Natalia Lopashenko, who claims with a very good reason that up to 50%, up to a half, of all actions classified as crimes in certain articles covering economic activity can be painlessly decriminalized and classified as administrative offences and even as civil delicts. Here, in this connection, there arises the question, what is happening today with the world crime and crime in Russia? What I would like to say here is the following. A careful study of Russian foreign papers reveals a curious fact. It reveals an absence of any absolute, not relative, the absolute indicators of crimes committed in the world. Recently, there has appeared a figure which shows that the number of crimes committed in the world on an hourly basis equals 200,000. Simple arithmetic suggests that yearly this number would amount to 1,700,000,000 crimes. Were this to be the case, then, considering the world population of 6.7 billion people, the world would have most likely collapsed under the pressures of uncontrolled crime surge. And because we are lucky not to see this happening, the truthfulness of these figures remains rather questionable. As I and some of my colleagues have calculated, the number of crimes committed annually constitutes from 590 to 760 million, which is a high figure too. This makes us study tendencies in world crime and single out those that we face today and we have to fight. These tendencies include the so-called latest trends in crime development in the past 100-200 years. The first of these is intensive growth, which outplaces the growth of populace, expanding spheres of criminal activity, mercenariness of motivating criminal behavior, higher levels of organized crime, better technical capacity and levels of self-protection, using even more destructive ways and means of committing a crime, increased damage caused by criminal activity, transnationalization of crime, unification and feminization of perpetrators, increasing social danger of criminal activity, and so on. Among the latter, a great in its scope is digitalization of crime. Just one commentary on the first tendency of constant growth of crime and its scope. It appears to contradict the statistics we have here in Russia. As we know, less than 2 million crimes are registered annually. As a matter of fact, we count 2 latent crimes, 2 unregistered crimes. The number of crimes committed in Russia varies depending on the source, from 5 million to 15 million. According to some observations, to 60 million crimes. Taking into account the number of pseudo-crimes I mentioned earlier, actions criminalized in our criminal code, the figure appears quite realistic. In our plenary session today, we will discuss the issues of analyzing these tendencies, not only of stating the presence of conflict, but also of looking for means to mix these processes by means of looking for a compromise in a in the criminal law too. I am now giving the floor to my colleague who's going to announce the first speaker.
Good afternoon, everyone.
Good afternoon, everyone.
It's all over
Everywhere in the world the same thing happens. After lunch, only but a few people are available, but I'm glad that quite a lot of you are still here. This particular session is jointly hosted by the International Society of Criminology and International Forum of Crime and Criminal Justice. I want to tell you about the International Forum of Crime and Criminal Justice. The entire credit goes to Professor Bing Song Ko. We just lost him a few months back. We had a forum in China where we all met as an International Society of Criminology, which looks at transnational crimes. I will not take much of your time, and I would like to invite first a friend. Juan Carlos Ferry Olive, and he's a professor of criminology and criminal law in Spain. I want to make it clear that everybody will not have more than 10 minutes, and we will finish by 5 o'clock so that we can have some time for questions. So may I now invite Juan Carlos, please.
It is an
honor to be here in Russia with such prestigious criminal justice experts from all over the world, essentially with very good friends. Professor Sani, Professor Denis, thank you very much for your work, for the work of your team, and for your hospitality. We are speaking about legal reconciliation, and we speak about plea bargaining
in the United States and in Spain.
In the United States and in Spain. In the United States, in the criminal procedure system, there's a wide discretion in the hands of the prosecution. The solution, which is based on the use of incentives and the American legal system tradition, which dates to the Civil War, or even earlier. It gives the public, and specifically the Public Prosecutor's Office, the possibility to decide very freely to stop or continue the criminal procedure, and even to use it in the United States, in the exoneration of the defendants. The USA has a long practical solution to avoid long and costly trials, to work towards a better use of resources of the public prosecution procedure. This rule can be expressed as one of three opportunities. That is, there are negotiations and there are legal consequences. The public prosecutor may even waive criminal proceedings. This would make it possible to forget a penalty in exchange for a denouncement. It should be borne in mind that in the American system, the judge is usually in a passive situation, since the control of the procedure is held by the parties, and therefore the negotiations are of utmost importance. Plea bargaining, which began as an exceptional solution to regularly solve a limited number of cases, is today the main procedure. Since today, the exception has formed the rule. Usually, judges and academics pay little attention to the negotiation process. There's always the possibility of a trial later to ensure the fairness of the argument. The state merely offers the possibility of a fair trial. The government offers the possibility of the state protection. However, this approach has been changed in some recent years in the state Supreme Court of the United States. Today, the oral trial system has been replaced by a system based primarily on arguments. A situation that requires an interest in procedural arguments. It is a mechanism with great international expansion, which has been born over the United States borders, but also not with the same force. Not with the same force. As a result of all, criminal proceedings are not allowed to be so widely available. On the contrary, a system of regulative opportunity has been created. Negotiations power is admitted for certain kinds, imposing limits or seeking alternatives so that the rules of criminal and procedural legality are expanded. This is the place of the soundest of arguments in the Spanish criminal process, as the specific form of the rule of regulative opportunity that produces some positive results and many problems of interpretation. Negotiations can be constructed in different ways. First of all, the election of the charge by the prosecutor, charge bargaining. Secondly, it is to take the lesser of the sentences that would correspond to the one previously agreed by the prosecutor and with reference to sentence bargaining. That is the solution that would give some advantages to the defendant. Academics consider that it is negotiated under the shadow of the trial, considering the influence that the evidence will have on the trial and limitations to the penalty with respect to the one that would have the possible result of the trial. However, there is also another view that does not see that approach as simple. Many circumstances that influence the results of the negotiations process are as follows: extortions in the process, wrong advice, not accepting excessive penalty, accepting life imprisonment. The main difference between trial and bargaining is the lack of collection of evidence to establish the defendant's guilt or innocence. In a system such as the American one, which seeks to rely on the presumption of innocence and the presentation of evidence in court, both plea bargaining and penalty are impossible. But at the same time, trust in the entire innocence system is in deep crisis. Free admission of guilt is valid as evidence to recognize the defendant's guilt without the need to impose the proof of the charge on the prosecution. This is where plea bargaining takes place between the prosecution and the defense side. This is the model that predominates in many countries. In the United States, it is enforced with other rules in some other countries, such as Spain. Since the 1980s, Europe and the rest of the world have been influenced by this very model, and so they have the International Court of Justice. Spain could not be left out of the system, and the administrative letter of 1999 of the Attorney's Office is seen as a crude extension of the system of arguments. In Germany, Professor Schulman says that European continental criminal procedure has entered a deep crisis precisely because of the adoption of plea bargaining. This is the crisis of the criminal law and the structure itself, which cannot be understood by the professionals in the plea process, or they might pretend that they do not understand. We believe, however, that these concepts must be analyzed. There are both positive and negative aspects to plea bargaining.
with a viewpoint and not one based exclusively on
Мы не можем
antagonists.
говорить о том, что мы основываемся только на одной.
There is an important positive aspect to pre-bargaining. From a statistical point of view, there's a reduction in the number of criminal proceedings, which brought about good results in both the terms of economy and the administration of justice, in addition to saving economic resources for the state.
Улучшить администрирование в сфере правосудия.
The work of the prosecution, the
The work of the prosecution and the defense will only benefit from this perspective.
От этого одновременно только выиграет. С этой точки зрения
We can find a very general approach. In this way, in this perspective, we can also find some positive aspect
для следователей,
for investigators as well, in the same way.
functioning of criminal networks.
Поэтому
With criminal networks and organized crime active today, the evidence base can be rather demanding and very little. The arguments I have quoted today can be used both for and against the system. In a pre-trial agreement, we aim at a reconciliation before the trial starts. In the United States, in Germany, in Spain, there have been experiments made with both positive and negative results. For example, defense lawyers and prosecutors sometimes would opt for trial proceedings, not willing to conclude a pre-trial agreement. However, it is simpler, more beneficial for all the parties involved if the pre-trial agreement is concluded. Having said that, we understand that the side of the prosecution is always interested in the evidence, and if we regulate the system, then all the parties will win. The defense can waive a certain decision, refute a decision, and in the majority of cases, we understand that there are no ideal conditions to implement a pure experiment.
Разумеется, мы понимаем, что в большинстве случаев у нас не идеальные условия для проведения прямо такого чистого эксперимента.
The United States system can suggest something of the kind, and still, in its many years of experience, they have committed some mistakes. In conclusion, I want to say that criminal justice requires social education of sorts, social training of sorts. We need a certain machinery accessible to both the defense and the prosecution, some software accessible to both sides. It is necessary that society plays an active role in changing the system of justice and its administration. The system more or less resembles a supermarket, where you look at the predetermined prices and you assess and accept it. There are no negotiations involved. They are not possible, and we do not want any McDonaldization of the trial proceedings. It would have been analogous to fast food restaurants.
И очень многие преступники, например, в США попадают еще, им выносится приговор до
Thank you.
такового. Спасибо.
Ladies and gentlemen, I have to introduce some corrections into the procedure of introducing our speakers. Two of them will be showing a presentation and will rely on technical support for this, which is why I will be inviting the speakers in a different order.
Будут приглашаться к выступлению в качестве спикеров наши коллеги не в той последовательности, как она.
So the order will be different by itself, not the way you have them in the program. I'm giving the floor to Yuri Borisovich Melnikov, my colleague and student, candidate in law.
Является представителем.
He is the.
Возглавляет Приморский.
He heads the Primorsky Krai Department, and he's the Human Rights Ombudsman.
Спасибо.
Thank you.
Добрый день, уважаемые коллеги.
Good afternoon, colleagues and friends.
Я не буду говорить здесь о международной.
I will not be talking about international crime here. I will only continue the topic of our first plenary session. First, I would like to express my sincere gratitude to the organizers for the opportunity to speak here. I have visited many conferences, and I can say that I admire the way this one is organized. Thank you very much. The order of my presentation will be as follows. First, for our foreign guests and students, I will give a brief introduction into the legislative implementation of the competences of the Human Rights Ombudsman in the subject of the Russian Federation. Then I will go into the reasons for my colleagues' worry over violation of complainants' rights in pre-trial criminal proceedings, and then I will share my ideas of protecting victims' rights through the prism of reconciliation. In 1997, Russia created state institutions of human rights ombudsman on two state levels. Federal constitutional law of human rights ombudsman in Russia was enacted. There appeared a human rights ombudsman in Russian Federation, now Tatyana Moskalkova. In the course of several years, all the subjects of Russia adopted regional laws, according to which human rights ombudsmen started working in republics, regions, districts and federal cities. Regional human rights ombudsmen are appointed by representatives of legislative bodies in Russian subjects by secret ballot. Human rights ombudsman of the Russian Federation is not superior to his colleagues in the subjects of the Federation. He only coordinates their work. Before the candidature for the post is presented for discussion in a regional legislative body, it is considered by Human Rights Ombudsman of Russia. The post of the Human Rights Ombudsman of the Primorsky Krai, as in other regions of Russia, is established as further state protection and provision of rights, freedoms and legal interests of the man and citizen. The basic tasks of the regional ombudsman include the following: cooperating in the remedy of rights violated and procuring the guarantee of state protection, taking measures to improve the human rights legislation and aligning it with the international standards, overseeing how the human rights are observed by local governing bodies and government officials. Today, to my mind, the demand for justice and change for the better is higher than has ever been, and in this context, observing rights and freedoms of citizens plays a crucial role in safeguarding the activity of federal and municipal authorities. With regard to the competence and role of the Ombudsman, I believe that this institution is highly demanded and vital, since the Ombudsman functions as a moderator and a connecting link between society and government, facilitating the rights of man and citizens as well as their protection. The Ombudsman is thus a multi-purpose institution, a doctor, a psychologist, a fireman, whose task is to decrease the temperature in the heat of the conflict between the state and its citizens, to establish a viable dialogue between government officials and citizens. Last year in December, the President of Russia held a closed meeting for regional ombudsmen only, which emphasized the importance of the institution itself and set the aim of solving people's problems locally. One of these problems is violation of the victim's right in criminal cases. We talk a lot about observing and protecting the rights of suspects and defendants and convicts. It is, of course, necessary. It is just and right. But to my mind, we have lately been overlooking the rights of the injured party. I kept asking myself the question in the first plenary session, how reliable is legal procedure of the victim's right? Legal protection of the victim's rights, I would say not very. The constitution of the
Анализ, поступивший от уполномоченных по правам человека в субъектах Российской Федерации информации, свидетельствует о росте обращений граждан с просьбами оказать содействие.
Data analysis provided by Ombudsman and subjects of the Russian Federation reveals growth in citizens' requests for assistance in protecting the constitutional right of protection from unlawful actions. In 2017, there were over 4,000 claims made in this regard. In 2018, the number exceeded 4,500. In the first half year of 2019, it was more than 2,000 claims. The yearly growth constitutes almost 10%. In our view, it indicates unfavorable trends in protecting victims' rights compared to the number of lawful actions registered regionally. The number of these claims isn't really high, but as a rule, these claims are made at the last resort, when the citizens themselves state they have lost all hope. Human Rights Ombudsman consequently provide this assistance for them. As we can see, every sixth case was assisted in 2017, every fifth in 2018, every fourth case in the first half year of 2019. Looking at these figures, we can conclude that there are serious problems with citizens realizing their right for protection from unlawful actions. I have outlined some of these problems here. The first one is unlawful and unjustified refusal to initiate criminal proceedings. According to the Prosecutor's Office of the Russian Federation, prosecutors revoke 2 million unlawful orders of this category annually. Let us look behind these figures. Taking into account the fact that all law enforcement agencies issue a little over 6 million orders of this category, we can see that every third of them is unlawful. If we take a broader look, I looked at 6 months of the past year in Russia. Every 13th criminal case of all the cases existent is reopened. Because the victims complained about unlawful orders, the orders of rejection were revoked. This is the case with further investigating criminal proceedings initiated. How much is that? That would be the average mean. In the Fringe, Primorsky, Krain, and Altai, it's every fifth case, in some regions every sixth case, and so on. To my mind, these figures are alarming. As great Cicero said, the greatest temptation of crime is based on impunity. Another problem that Ombudsman mentioned is the absence of any guarantee for compensation of damages to the victim as a result of the crime committed. To solve the problem of implementing the provisions of the Constitution of Russian Federation and observing international standards, there has been a suggestion to create a state fund for compensating damages with further recourse action against the convinced to protect the low-income group. We know it very well that if a perpetrator is in detention, there are employed, 30–40% of them are employed, but out of the 30–40%, only half has civil action started against them. This is why many of poor victims do not seek compensation of the damages. Besides this, many ombudsmen propose that the victim should have legal defense paid for from the state budget and that this be ensured at the legislative level, with the guilty party bearing the responsibility for compensation to the state. The first step can be the federal law on free legal aid in Russia, with necessary provisions specifying characteristics of the socially challenged group. To solve the problems outlined, we need to perfect the practice of law enforcement and change the current legislation. Introducing a reconciliated with the criminal law on pre-trial stages can become one of these changes in protecting the victims' rights. It can be a good solution. In questions of compensation for damages to low-income groups especially, as I have already said, the Ombudsman is a mediator between the individual and state bodies. In their work, they have to resort to negotiations, mediation, and in this connection it would be expedient to solicit the services of non-profit organizations with a view to provide further opportunities for realizing the state guarantee to ensure individual rights and freedoms. Such organizations can help conduct mediation procedures. It's important to work through ways of restorative justice with the representatives of such organizations to better protect the rights of victims. I would like to express a thought that might not be immediately welcome. It would be logical to introduce into the criminal code of the Russian Federation a clause on the possibility of mediation between the victim and the accused, defendant, suspect for negotiations, and alternative way of reconciliation between the parties involved. On the one hand, such a possibility already exists in Article 76 of the Criminal Code, mentioned today in the first part of the conference. It provides for exemption for criminal liability following reconciliation with the victim. A person who has committed a crime of light or medium gravity for the first time may be released from criminal liability if he has reconciled with the victim and restituted any damage inflicted on the victim. The same provision exists in Article 76.1, 76.2 of the Criminal Code of the Russian Federation, but we need to add a clause on the necessity of the victim's agreement to the criminal procedure law. The very procedure of reconciliation on pre-trial stages needs to be further regulated, I would suggest. Besides official representatives who solve the issues, work with the victim and the defendant, criminal investigators on one side and lawyers for the defense on the other, that we should have official mediators who would work with the victim on their own initiative. Mediators should be former employees of law enforcement and judiciary bodies. Then the investigator and the victim will choose the mediator from a special list with account for the region of residence. Similar mediation and reconciliatory procedures are already stipulated for the civil, administrative and mediation law. Punishing the criminal is only minimally conducive to the compensation of moral and physical damages caused to the victim. In the forum in Vladivostok, there was a representative from FRG who represented Max Planck Society for the Advancement of Science. They said they had conducted thorough survey and analysis and found out that most victims believed their state had improved after mediation, that they had more opportunities to compensate for the damages caused by the crime through mediation than through criminal proceedings. Therefore, developing reconciliation in pre-trial proceedings will ensure greater participation of civil society in state judiciary mechanisms and will also allow the victim to play their role in protecting their rights in a trial. Thank you very much. Thank you very much, Yuri Borisovich. If I understand it correctly, a certain compromise in resolving a conflict between the victim and the criminal, from the victim's point of view, is criminal prosecution of the offender. Don't quite understand what I mean. Not releasing the defendant from the criminal liability, but prosecuting them in those cases when criminal prosecution was discontinued, and then after the victim's insistent claims, the cases were reinstituted and taken to the logical resolution, and the offender was properly punished. This goes without saying. What are the ways does the victim have to protect themselves? Is there a compromise possible? I don't think this is a compromise. This is a necessary condition. I can see a compromise in the investigative proceedings. It's increasingly difficult for the victim today to protect themselves, making alternative solutions indispensable. One of the solutions gives an opportunity to all parties. The offender would be interested too.
Не может возместить ущерб, причиненный преступлением. Вот в чем смысл. Дорогой Александр Иванович, спасибо.
Because it would mean not being detained and unemployed without any possibility to compensate for damages. Thank you. Thank you, Mr. Yuri Melnikov.
May I request the next speaker, Juan Lemar Blount-Hill. He is a PhD Senior Research Manager, New York City Mayor's Office of Criminal Justice in New York.
10 minutes, please.
10 minutes, please.
Good afternoon, everybody.
Good afternoon, everyone.
So my role
in this conference today is a little bit different. I'm going to touch a little bit on the Russian voice in the criminological discussions, like this one on reconciliatory justice. Throughout this conference, we have been listening to scholars of law discussing criminal law, and my role in the preparation for this conference is the following. I have conducted interviews with the most reputable journals presenting international research and looking for Russian scholars based in Russian institutions that might give some perspective into how this problem is framed in international circles. Amazingly, however, there were no articles that I found that presented the case in the Russian perspective on reconciliatory processes. From a social standpoint, work on this is happening and the conference is proof. But this work cannot be reaching as broad an audience as it should, in the way it reached the audience this afternoon. Just this month, I completed interviews with 60 journals of international scope, international associations held in high regard. I was looking into the magazines published in the English language, which is the most widely published language in the whole of the world. Legal spheres including. English language forums, however, tend to have less influence in some specific countries. Still, there's the global realization and understanding of the problem because it has acquired a global stance. This does not only relate to European countries and the American continent, but this relates to the world in general. In an English-speaking culture, we tend to hear some Russian voices. Not always, sadly, in English or in English with a Russian accent. In my research, I have concentrated on journals of professional nature, on papers published in Russia or by Russian scholars in two different official journals. These articles were published in the Official Association of Criminology in the USA, the European International Society of Criminology, Asian Society of Criminology, Australian Society of Criminology, that of New Zealand, Britain, Australia, Canada, the Association of Criminal Law in Africa, Scandinavia, and some other countries.
Другие страны, это как раз те ассоциации, чьи издания я изучал.
These were the countries whose journals I have studied. In half of them, only in 8 out of 16, there were articles which at least mentioned Russia or Russian institutions. I tried to look for materials published by Russian criminologists by Russians. They are rather famous, and I was interested in what was happening there in criminal law. Such journals not being hugely popular in the USA, I searched for information on Russia in other legal journals. As a criminologist, I was interested in that very aspect. Those editions brought up a very interesting topic. Administration of justice is not only based on legality, it is based on sociology, psychology, victimology, philosophy, geography, so on. These are the basic disciplines that make justice a social phenomenon. It is not only a legal trial. We need to understand the technical specifications of these processes, which might be very helpful. Why do politicians behave they do? Why do they adopt certain laws in the sphere of criminology? How important is this for us? How available are these opportunities for people who make laws? It is very important to be able to understand the language we all use. I was trying to achieve a certain understanding of how crime victims are treated in different countries. Some speculate on that, some start philosophizing. I have read 44 articles on the topic, with 14 of them having been published in the USA, and the rest from international journals, professional legal journals. Interestingly enough, some of these were published by the American Association of Criminology, and I found a number of articles, 9 of them to be more specific, that were dedicated to Russian criminology. This means that there's an interest in Russian criminology. However, this was only one journal that published a series of articles in different editions. 5 out of 16 journals I analyzed were dedicated to a specific topic.
Были посвящены какой-то конкретной теме.
Compared to international and American sources, compared to American sources, international journals have few articles of this kind, and many of them do not mention Russian criminology at all, which is curious. I was curious to see the Russian perspective on this, and I was interested to know whether you had organized anything similar. Mr. Yakov-Simonsky, if I pronounce the name correctly, is a very famous Russian researcher, a very well-published Russian researcher in the field. He has already had 3 papers published in Russian criminology, and there are 2 more authors with 2 papers each published. There are only 5 people I found that wrote 15 articles out of the 44 on the subject of Russian criminology. These were rather solitary voices, which provided an interesting interpretation of some Western theories. But we also have to look at the Russian reality to be able to explain the social phenomenon that exists in Russia, but that can also be applied to the whole of the world. Western criminologists can share their experience and offer a new perspective, which would be interesting to analyze. It is necessary to share our knowledge, and it is important to take into account our competitors' experience, our own experience, to be able to understand complex social processes. Technically, we are a society which we have to remember, and the law cannot account for all aspects of justice administration. It cannot encompass all of that. In Western countries, for example, much time is spent on investigating the motive of a crime. What caused the crime to happen? To conclude it all, me myself, I'm not a Russian, and I have only, for the first time in my life, spent several days in this country. But I would like the Russian voice to be louder, to be well heard. I am a Western researcher, and I would like to study more of your works, to hear more from you, and I would like your voices to be louder. Thank you very much for your attention, and I would be happy to learn from you. Thank you, Kwan Lamar. It's very interesting, very insightful. I don't often study your research, but much as I know, the university, they only publish Scopus articles, and many of them do not reach the university system of Scopus. It was interesting to hear out an interdisciplinary approach to criminology, the scientific approach, the methodology. How science can influence and change the system. Thank you very much. And now I would like to give the floor to my friend Miguel Abell Soto, Professor of Criminal Law of the University of Santiago de Compostela in Spain.
Santiago, España.
Добрый день, уважаемые коллеги. Меня зовут Miguel Abell, я из Испании, университет
I am from Spain, from the University of Santiago de Compostela, and I am the professor of criminal law. My report is called Admission of Guilt in Economic Crimes and Money Laundering and Criminal Responsibility of Legal Entities. Today I
хочу поговорить с вами о том, насколько мне приятно
primarily want to say how pleased I am to speak for the first time in the greatest country of the world, in Russia, to speak in the wonderful city of Yekaterinburg.
в великолепном городе Екатеринбурге.
Thank you very much.
Благодарю вас, всех уважаемых
the participants of the conference.
И уважаемого Данила хочу поблагодарить
And I thank
за
Daniel
то, что
for
вы
having invited me here. Admission of guilt in economic crimes in the Spanish system of criminal law can be not only
элементом примирения,
an element of reconciliation with the victim, but also reconciliation with the society.
Смягчающих факторов признания в преступлении и
This can be seen as a mitigating factor,
а также
both the admission of guilt and the compensation for damages, probation or suspending the penalty through negotiations and bargaining on the admission on guilt is also possible. The fourth clause of Article 21 in the Criminal Code of Spain contains a mitigation factor which presupposes lesser punishment if criminals admit their guilt before they learn of the trial proceedings initiated against them. In cases when there are conditions for resorting to such mitigating factors and the conditions are not met, it is possible to resort to Clause 7, analogous mitigating factors. Secondly, Clause 5 of Article 21 in the Criminal Code of Spain also contains another mitigating factor connected with admission of guilt. If the criminal compensates for the damages caused to the victim or reduces the damage and influence before the sentence is passed, this mitigating factor can be applied as analogous in line with Clause 7 of Article 21. Moreover, civil responsibility is a requirement for the suspension of the penalty or probation in line with Clause 3, Article 82. Law 1/2015 of the 30th of March states that payment liability is sufficient, and it adds a new requirement of consequation of the liability to facilitate confiscation. Law 1/2015 introduces new terms for Article 83 of changing the penalty suspended for factual damage payment or compensation on the damages caused, as well as keeping to the requirements of the agreement on mediation. Here, we have the first instance of the word mediation used in Spanish legislation, legislative code. In Article 24, 8.1. Moreover, there are negotiations on the admission of guilt, bargaining on the admission of guilt, and in this case the penalty is also alleviated, shortened as well. As concerns criminal responsibility of physical entities, the responsibility for money laundering, the retribution system reforms of June 2010 introduced changes to criminal responsibility of legal entities. According to this reform, money laundering, alongside with some other crimes, became part of this new reformed system of criminal responsibility. Law 1/2015 also changed the norms used earlier. The technical improvement of Law 1/2015 is surprising, since it stands in direct opposition to the exemption of criminal liability for a legal entity which deals in money laundering. It cannot exist due to the acceptance and enforcement of the program with preventive measures, even if the interpretation of the law in accordance with the principle of verification allows for understanding in a relative sense, allows for insignificant changes in its application. This law is used in insignificant scale in accordance with the reform of 2015. It replicates the widely criticized law of 2001 in Italy. This Italian law introduces a partial mitigating factor of partial accreditation. In the United States, we can actually find instances of observing this law when legal bodies usually are not relieved of their legal liabilities. The mitigating factor of partial accreditation that exists in Criminal Code of Spain as a system of preventive measures cannot be used as inadmissible use of evidence. It often happens so that the mitigating factor completely combines with the negotiations in the bargaining on the admission of guilt, which serves as a powerful stimulus to discontinue any activity of a company which leads to immediate losses. The same happens in the USA, which is the birthplace for such negotiations on plea-bargaining. And such agreements on criminal prosecution can be concluded between companies, in favor of companies, and between companies and the prosecutor's office. For example, we decide on the contradictory agreement between the Department of Justice and the Swiss bank, which pays a huge fine to continue working in the US. The law on criminal and criminal acts and courts adopted in England and Anglo-Saxon legislation also introduces such informal agreements. These small punishments are also possible with their rejections when hearing out the sentence. Besides, in plea bargaining by legal entities, after the crime has been committed, this fact can serve as a reconciliatory element both with the victim and society, and can be taken as a mitigating factor as seen in Article 31(4). It presupposes pre-admission of guilt before the trial proceedings are initiated, cooperating with the investigative bodies, compensating for damages caused to the victim, and also participating in the corresponding program on crime prevention. Thank you very much for your attention. Thank you very much. The next speaker is Valentin Ivanovich Mikhailov. Professor, Doctor in Law, Chief Scientific Advisor of the Institute of Legislation and Comparative Law under the government and of the Russian Federation. Good afternoon, dear colleagues. I'm very thankful to the organizers for the opportunity to exchange specialist opinions and views. The challenge of the conferences like this lies in the fact that all homemade presentations have to be discarded. I have been preparing my presentation for today, of course, and some of the speakers today have inspired me to share different ideas with you. I will have to improvise to a certain degree, so please forgive me for that. The thing is that we have been talking extensively about reconciliation in criminal law, but there arises a question. Reconciliation of what parties? Yes, there is the perpetrator who has caused some damage. But then again, damage to whom? Who is the owner of that privilege that has been perpetrated? We arrive at questions of methodology which are at the heart of not only legal consciousness, but public and social consciousness that have been somewhat secondary in our discussion so far. As I understand it, in the Roman-German legal system, and here in Russia too, protecting the individual is a bounden duty of the state. In the criminal law of 1845, any damage concerning liability privation in cases of self-defense was considered legal if there was no possibility for the defense to appeal to immediate authority. This is not a direct citation, but there is the word authority there. In our modern constitution, in the second part of it, there's a part explaining that the government grants every individual the right to protect their rights and duties. This is the second part. The first part safeguards state protection of rights and freedoms of the citizen. These details reveal the fact that it is, after all, the government that takes on the role of the protector. This is the legal aspect of the question. There are also social issues involved. It seems to me that the basis of today's society is the sacred life of man. The approaches of this respect were very different at very different ages of civilization. Cannibalism and others. In the modern world, when a murder is committed, then the injured party is the whole of the society. Not a concrete person, not the relatives, but modern civilization itself. This is what it is built upon. Consequently, we are talking about reconciliation of the perpetrator who deprived the victim of their life and the whole of a society. Again, I'm going to say something that might run contrary to some of the ideas expressed earlier. I believe that criminal law protects the system of social existing relations, not certain beliefs. The previous speaker concentrated on that, not specific material beliefs, but the system of values, the system of relations, which has been developed by the present moment. It has been developing for ages and has developed by today. Therefore, in quite a large number of cases would be the proper word to use here, but we can also say crimes. Reconciliation can only be understood in the following way: reconciliation of the person who has committed the crime and society. The interests of the person are represented by the state, so we speak about reconciliation of the person who has committed the crime and the state. But this reconciliation can first and foremost be achieved through criminal prosecution. This is just a quick draft of what I think about the issue, and it may well be criticized. I may also be wrong. I have unfortunately been wrong many times in my life. In my speech today, I would also like to consider one more aspect, since we are gathered today in Kovalev readings. For me, at least, the most topical of Professor Kovalev's works is his work on complicity. He can be called the father of the theory that explains the amount of criminal responsibility of all the people who act in criminal complicity. The issue today is rather topical. Complicity today does not necessarily involve physical complicity. Both good and bad criminal acts can be planned by people 1,000 kilometers away from each other. A crime can be triggered by a good word that can lead to dire consequences. The question is how can these people that act in a sort of complicity be held accountable? Dear colleagues, I will remind you of the very essence. The essence of his accessory theory, that was perfectly formulated in his works, boils down to the idea of the perpetrator. There's no crime without a perpetrator. Whatever is done before the crime is committed is preparation for it. All the articles and norms of this specific part relate to isolated instances of crimes within the bounds of the Russian Federation, except those crimes that I will later on mention. Thereby appears the issue of complicity, that is forming a criminal unit, not a criminal organization, but a unity, is treated as a preparation for a crime. It is also from this premise that the study of multiple crimes proceeds. You might well remember the active dispute that was going on for several decades in the Russian Federation about prosecuting those involved in gangs or for complicity in crimes. Some punishment for offences committed within a gang would be mitigated. Sometimes a perpetrator would be punished for multiple offences and so on. Let us proceed from the premise that creation of a criminal unit is preparation for a crime. Then how would we explain the existence in the specific part of the criminal code of such crimes that would be independent by themselves, such as Article 2205.4, organizing a terroristic association, Article 2004.8, armed gangs, 209 gangs, 210 illegal criminal gangs, a whole plethora of articles. Today, I think, there is a certain inconsistency. The concept developed by Mitrofan Ivanovich should by no means be discarded, but the new facets of our reality have to be taken into account, processed, and suggested for further use by our legislator. Our legislator is physically aware of these complications and is trying to introduce some changes based on empiricism, with the aim to solve the problems of prosecuting those in complicity. Unfortunately, such practices are not always successful. These issues are also topical because last year, on the 1st of January, drastic changes were introduced into the criminal law. For instance, the word joint participation was taken out from Article 210, which writes out responsibility for creating illegal criminal gangs. We have always looked at this crime in the context of a more general doctrine connected with complicity. Complicity in the modern criminal code is based on the understanding of joint, intentional, common participation by two or more persons in the commission of a crime. Joint participation. Now it is different, and it also reflects our reality. The organizer of the criminal association is the person who created the criminal association, so that it commits crimes without the participation of the organizer. As much as I can understand it, this is not the complicity or accessory theory. This is something different. I repeat, we have many crimes like this. As far as I can see it, and those more knowledgeable in the subject can prove me wrong if that be the case, these crimes were written out on the basis of a different concept. The concept of criminal conspiracy, which says that several persons uniting to commit a crime with or without the crime itself is a crime by itself. This concept has not been in particularly high demand. Or maybe I have been looking in wrong places, but I have not found many papers devoted to this problem. One notable instance when we returned to this concept was the Nuremberg trials. We had to do so because the concept of complicity could not enable the lawyers to prosecute Hitler and his accomplices criminally. Within the boundaries of complicity, the perpetrator is the main figure. If law is not perpetrated, then the crime is not committed. It had to be proven that Hitler knew about every single murder of every single man, and it is then, much as I understood it from the papers I read, that the concept of criminal conspiracy was used overnight for that very purpose. Naturally, the practical problems of applying criminal legal norms in cases concerning joint participation of two or more persons stem from the absence of any theoretical basis. It is the absence of any theoretical basis that does not allow for proper application of already existent norms. I firmly believe that we cannot sentence a person to 8 years imprisonment for complicity. The same sanctions can be applied to those participating in a criminal organization. Just a minute. The problems I have outlined require further investigation and analysis, so that the legislator can be given theories that consider the present-day reality. We have to move further, even more so, because the accessory theory I've mentioned earlier is more than half a century old, and the reality today makes us reconsider the theory itself. Thank you. Thank you, Valentin Ivanovich. I'm not commenting on your speech, not asking questions. I know that you have to hurry to the airport, not to be late for your plane. Our compromise would be letting you go in peace.
Thank you.
Thank you.
Now the next speaker.
Our next speaker is Michael Jenkins, Doctor of Philosophy, Associate Professor of Criminal Justice in the University of New Haven in the USA. He is going to talk about Reconsideration in criminal law. Good afternoon, everyone. I would like to thank the organizers for the wonderful planning and for the opportunity to participate in the conference of this wonderful event. It is also my first time here in Russia. Today I'm going to talk a little bit about reconciliation in law enforcement agencies. I am an associate professor of criminal justice. I have been working with law enforcement, security and safety issues within that system. I believe you will see my report repeating some of the issues raised here before, and I apologize for having changed the title of my report, since I offered a different title. Alternative reconciliation practices in law enforcement. In the 1980s, in the United States of America, the police proved effective in fighting crime. Before that, they were only seen as a force reacting to crimes. They only focused on retroactive investigations and thus doing almost nothing to prevent crime and to protect citizens from victimization. In the 60s, 70s, 80s, there was a widely spread belief that crime has roots in low levels of education, in poor family conditions, in poverty, and therefore social policy was aimed at fighting these factors. It was an activity aimed at working with socially induced crime, aimed at reducing the influence of social factors on criminal behavior. Very much like in that octopus picture that we saw in the morning today, that showed tentacles, hands, as different aspects of society that are influenced by crime. And at the same time, the tentacles of society would also influence crime. That was the idea of social reasons behind criminal behavior. There was, however, very little space in that picture to show you the police and the preventative influence it can have. The 90s saw a rise in crime levels and numbers, which called for introducing preventive measures. It was believed that, firstly, people in high crime areas care less about grave crimes. Secondly, crime and disorder concentrated in certain areas inside the city, even in certain neighborhoods within the city. And lastly, the police could do something about the fear of crime and disorder. This was where the society stepped away from social crime prevention and looked at what could be controlled by the police. Some refer to this sphere of control as situational crime prevention, which by itself stands in opposition to social crime prevention. The police can change the very environment by working with it. One of the most popular ways to test this approach is the so-called broken windows policing. This theory claims that if some neighborhoods display signs of social unrest and physical violence, and the social norms are not being observed, then the people in the neighborhood receive a signal of a possibility to break the law without being punished for it.
нарушают социальные нормы этих районов.
The broken windows theory has many aspects, and many methods have appeared and stemmed directly from it. Unfortunately, the police in the United States focused on the belief that fighting social unrest can diminish the number of grave crimes, which led to excessive control and aggressive tactics on the part of the police in the name of law and order enforcement. This ran parallel with all other tactics employed by the police. Sometimes we analyzed the results of police activity against the number of crimes. That is, we looked at the arrests and contacts with citizens, at criminal investigations. The results of such activity included decreased crime and fear of crime, as well as decreased fear of police legitimacy. The crisis of police legitimacy was the result of that excessive control. Избыточного правоприменения. Then a decision was made to step away from the theory of broken windows in police enforcement and ensure more contact with citizens. The idea was that the police can implement positive social norms and can therefore lay the basis for other social reforms.
Закладывать основы для других социальных реформ.
Police legitimacy is defined as citizens' general state of trust towards law enforcement. The police are obeyed because they are open and just in the work with citizens. It is obvious that the initial law enforcement practices of broken windows influenced their legitimacy quite negatively.
Воздействовала на их легитимность отрицательно. И вот чтобы, исследуя вот эту связь между
the social situation and crime levels, we decided that it would be viable for the police to take on a leading role in the community and set the tone for other social measures and policies. Generalizing this model, we can see that all the aspects and preventive measures, improving education and living conditions, giving opportunities for professional training in unfavorable neighborhoods, can bring effective results. We can clean the environment, clean the neighborhoods. We can also function as security ourselves, as someone who is responsible for law enforcement. Our interaction with citizens comes down to overseeing order and law and preventing minor crimes that collectively can bring harm to the community. So it is the community that suffers from these crimes, not an individual only. If a certain environment is characterized by higher levels of crime, then it is the citizens that will be suffering and will be afraid of going back home
беспорядка, тогда граждане могут бояться возвращаться
They can
домой.
also feel uncomfortable in public spaces, and the concentration of unrest in these neighborhoods
И концентрация беспорядков в таких районах имеет
can lead to
множественные
multiple
последствия для
consequences in
социально-экономической
social and
жизни.
economic life. This quote here says that the vast majority of crime control actually results from the everyday activities of citizens. An effective crime control strategy is one that not only acknowledges and embraces the importance of residents in preventing crime, but also seeks to enhance their ability to do so. This would give them the opportunity to set the norms and to enforce law, which is necessary to realize this social policy effectively. Thank you. Thank you very much, Michael.
Michael Jenkins.
Michael Jenkins. This was a very interesting report, and I agree with the psychologists who claim that a man is never born a criminal, he becomes one. I agree that social injustice and poverty are conducive to a rise in crime levels. This is a new way of looking at the problem, and thank you for that. Dear colleagues, I have a small announcement to make to the students present here in the audience. Your buses are leaving for the city at 5 p.m. sharp. And you still have 20 minutes to catch the bus. I also hope that the information that you have received today will be useful to you in criminal law and criminology, and that the day you have spent with us will not be spent in vain. Thank you.
Okay, and
the last speaker we have of the session is Isabel Moron Penvas. She works as a judge in Huelva, Spain. Good afternoon. I apologize for being the last speaker for today. I will try to be very fast so that you do not kill me if you come late for appointments today. I would like to thank the organizers of this conference because I think it is the only way for me to come to Russia. It has long been my dream to do so, so thank you very much for the opportunity. Yes, I remember that I have to be quick. I'm going to talk about negotiations in criminal law. In Spain, in particular, we have a system of conformity, a sort of agreement, a consensus of sorts. My colleague, a professor, spoke today about positive and negative sides of the system, and I would like to dwell upon the negative side more, especially on what concerns basic procedural rules. Today, there are a lot of voices. There are many people who believe that this institution is neither just nor efficient. They say that collecting evidence based and aimed at the completion of a pre-trial agreement is the classic way, the good way to conduct negotiations. When we talk about negotiations, agreements, we need to remember that this also influences the trial, the legality and the quality of it. In Spain, the procedural rule is very important, and judges primarily pay attention to that when they indict a criminal.
Нам необходимо всегда обвинять всех преступников.
There is also the rule of opportunity working in the USA, which basically comes down to giving people the opportunity to state their case. In Spain, the system of negotiations does not work quite well, in accordance with our tradition, because we traditionally indict criminals. But we still try to use all the possibilities of the system. Equality, the right of equality, the right for equality, has also influenced the system of criminal courts. Although criminals have to accept the responsibility for their crimes when the defendant hears out his sentence, we can potentially offer a milder penalty for not going to trial. The agreement will benefit all sides: the defense, the defendant, the prosecutor and the judge. In view of this, the terms of the agreement offered may be various. That is, the prison term may be shortened. In Spain, in Spain, that is not possible to such a degree. We can only negotiate a lesser punishment. We cannot free people from criminal responsibility with legal bounds.
Но это все, мы не можем освобождать людей. Это все в рамках закона, разумеется.
We understand it very well that the law presupposes a certain minimum sentence and a certain maximum sentence for a certain crime, and we try to reduce the possible sentences within these bounds. What we are somehow forgetting is that an innocent person can be convicted, and that then the system itself, the law and order, the police, the courts can impose a certain sentence. And then we have to protect the injured party and at the same time convict the man guilty of the crime committed. Lately, the detractors of this system, there have been many arguments against the system because it is asymmetrical, the parties are not equal. For instance, the prosecutor can offer some incentives that the defense cannot offer, because the defense is not authorized to conduct any negotiations.
Сказать, что да, я сознаюсь, я признаю свою вину, не надо больше работать, ни судье, ни прокурору, ни адвокату. И, как правило,
as a rule, we know that too, the defendant is the only party that knows the truth. The defense party knows it. And then again, the prosecutor's office, the resources there, they prove to be incomparable on the side of the prosecutor and the defense. Economic resources and human resources are incomparable. Anyway, in conclusion, it was not only equality, not only legality that influenced the system of negotiations in criminal law, but also traditional values such as morality, presumption of innocence, freedom of speech, and so on. Yet again, there are people who claim that the system interferes with the one already established in Spain. There are many differences to the system itself. We have no jurors, for example.
Как правило, у нас нет присяжных.
In Spain, we have 6 different procedures, and in every one of them,
Наша система.
Negotiations procedure would be different too.
6 различных процессов судебных, и в каждом система переговоров
And the assistance will be different too. In concluding a deal, concluding an agreement on an early termination of a prison term, all the legal facts, all legal qualifications, all claims are taken into account. We need to understand all the facts and accept them. We need to understand what the defense lawyer and what the prosecutor can propose. In Spain, this system exists in the sphere of economic crimes, tax crimes, for example. There has been recently a case involving a famous footballer. He is very famous, I'm not going to reveal his name. He received large amounts of money from his advertising, not his sporting activity.
Им крупные денежные средства от его рекламной деятельности, не от футбола, в общем-то, не от основной профессии. И он немножечко старался укрыть.
He tried to conceal the fact, which was unacceptable. However,
разумеется, не могли.
A prison term was unacceptable too, because a football career is too short.
Не могли согласиться на тюремное заключение, потому что карьера футболиста.
The defendant had
Они
to pay all the fines.
миллионы для того, чтобы
He had to pay taxes on the company that
налоги,
he was trying to
которые они
hide.
пытались укрыть, и старались
All attempts were made
смягчить приговор
to
и
mitigate
избежать
the sentences
любым способом тюремного заключения. Я думаю,
and avoid imprisonment to force.
должна работать каким-то
I think that this system has to work somehow, because famous players, famous footballers have many capabilities, more than usual criminals do. They can change prisons, for instance.
Поменять тюрьму, например, если им одна не нравится, заплатили и переехали.
They can pay and just change their location. These are also negotiations of sorts. This is how the system works so far. This is all I wanted to say. Well, I think we still have 5 minutes for questions from the audience. You can ask questions to any of the speakers. Thank you very much, Abell. If you have any questions, ask them to the speakers. Feel free to ask the speakers. Moreover, if anyone wants to start a discussion, you are very much welcome. We still have 10 minutes left.
No one?
No one?
Вопросов нет, кажется.
We are the best moderators.
We are the best moderators. Then we will be making some conclusive remarks to our plenary session. We have heard today a series of reports, all of them highly informative and interesting, as well as practically valuable. We can arrive at several conclusions, proceeding from the results today. First, the organizers of today's Kovalev readings have raised an original, non-trivial subject matter for this discussion. Then, secondly, the problems under discussion have proved complex, and thirdly, every speaker today not only have tried to analyze the problem of compromise within the boundaries of the criminal law and more broadly in fighting crime, they have also tried to make their own contribution and recommend ways of fighting crime, not only with stark repressive measures, but also through compromise. I would thence like to add some commentary and my own observations. Lately, we have seen the general tendency of humanization in criminal repression, in Russia too. This can be observed in the form of condonation or impunity. The changes are first, of course, introduced into the criminal code and then realized in practice. This is both an attempt to broaden the sphere of the notorious administrative prejudgment. I am strongly against this tendency, for I think that we cannot mix the charisma of our criminal law with administrative prejudgment. But still, we can see this tendency developing. The problem of compromise in the criminal law, in my opinion, can be solved in more radical and not a very complicated way, by changing the inept, inert and amorphous criminal code for a more compact and tough one, preserving one of those essentials that, only those essentials that relate to the criminal code, and peel away more than half of those crimes that clutter the criminal code today. If this were the case, then we would not have to strain every nerve to find a compromise. That would be a different domain. And the criminal code would remain the criminal code, where the dominating, essential element of this legal sphere would still be enforcement. It would still be used with a very narrow cohort of perpetrators that would, so to speak, have the rightful status of the criminal. Sadly, hopes for such an outcome are rather few, and it is in the active criminal law of the Russian Federation and its application that we have to look for what we call a compromise in fighting crime. Thank you for your attention. Thank you for your work. Our panel session ends on this note, and it has lasted for 2 hours sharp.
Thank you. Спасибо. Thank you.
Уважаемые гости,
Dear guests,
на сегодня
today's research part of Comparative readings is over.
Сегодня вечером в 8 часов
We are expecting you, as the tradition has it, at the party at 8:30 today in the Center Club in Yeltsin Center. While you are waiting for your transfer, you can have some coffee in the lounge. Thank you.